All right, this is a lecture in defamation and the law of defamation in as it applies to journalists. It's not a course on defamation law as it applies to the sort of knowledge that lawyers would need, but it's a very useful guide for you as journalists. Defamation is essentially a remedy in law that provides damages to people who have suffered a reputational injury, an injury to their reputation. Defamation is a tort, which is a legal word for a civil wrong. It's a civil wrong is a harm that can be remedied in the court by way of monetary damages or in some cases by specific injunctions. The wrong is to harm your reputation. Now, it may cause you economic loss as a result of that, and that may go to the quantum of damages, but you can't recover that unless you can prove that your reputation has in fact been harmed, leading to a famous quote by Charles Barkley, an American baseball player, who said, "My initial response was to sue her for defamation of character, but then I realised that I had no character." And this, in a sense, is the nub of it. Reputation is the standing you have among other people. If you don't have much reputation or standing among other people, then defamation can be much harder to prove. In other words, the test is, will people think less of you as a result of what is said or written or broadcast or in other way published about you? Just to get some terms correct, in order, the plaintiff is the person suing and the defendant is the person or company that has published the defamatory material. As I say, the remedy is usually damages, i.e. money or an injunction, but usually by way of a monetary amount of damages. In New South Wales at the moment, the amount of damages typically awarded is less than $100,000, but it can be more. And it can also be payable, of course, by you personally as well as the publisher, so don't think that this issue is to be taken lightly. Defamation is an ancient right in law. In fact, way back in Shakespearean times, in Othello, Act 3, there was a famous quote, "Who steals my purse steals trash. 'Tis something, nothing, 'twas mine, 'twas his, and has been slave to thousands. But he that filches from me my good name robs me of that which not enriches him and makes me poor indeed." So it's an ancient and been recognised as an ancient ill, and remedies for it are equally ancient. Now, community standards do change over time. What would cause people to think less of you today, of course, is not always what would have caused a person to think less of you in previous times, and vice versa. For example, in 2014, would you think less of someone who, for example, was an occasional pot smoker? Would you think less of someone if you found out that they'd bought pirated movie DVDs back from Malaysia whilst on a holiday? What about if they had sex before marriage? What about if they had a mental or other illness? What about if a person was a cross-dresser or liked pornography? Now, community standards change over time, as I say, and once upon a time, of course, to say of a person that they had sex before marriage was highly defamatory because it would cause people to think less of them. It's hard to think today, with today's standards, that would be the case. So in other words, there's no absolute test for what is an injury to reputation. It depends very much on what the community standards of the time are, and that's where the jury in a defamation action has a role, because it's up to the jury to decide whether or not what was said or broadcast was indeed defamatory. That is, did it injure the person's reputation? And the test is, did it cause others to think less of that person? So, as I say, community standards change over time. Once upon a time, for example, to have said of a person that they were homosexual would have been grossly defamatory. It's quite hard to see that, and thank heavens these days, it's quite hard to see that that would be a defamatory statement today. So community standards change, and necessarily you have to evaluate what you're saying against that. Now, here's an important point. Is it always wrong to defame someone? The answer is that no, it's not always wrong to defame someone. if what you're saying is true and you have a defence for it. The law only punishes those people who do not have a legal defence. Now, in a sense, as journalists, if we're trying to write robustly about people and public affairs, then we probably are in situations where we need to call some people a thief or corrupt or crook, where we need to accuse people of wrongdoing. Now, that's defamatory, of course. To accuse someone of an illegal act or to accuse someone of being corrupt would be, in today's community standards, to cause others to think less of them. But for us to write that, of course, is okay, and we need to write that if we're, for example, doing investigative journalism of some kind. It's okay to write that, and it's okay to defame people if you have a defence. And, of course, the number one defence is that what you write is true. So defamation law tries to balance the right of free speech, that is the right of people to speak freely, with the right of people to protect their reputation. But there's an important balance here, and it's important you understand this, that there's what I call a defamation equation. That is, if you publish something with defamatory imputations and that person's identified, that equals defamation. So publication plus an imputation, that's a defamatory imputation, plus identification, that is the person must be identified, that equals defamation. If I say, for example, all politicians are corrupt, it doesn't allow Joe Hockey to sue me because I haven't identified him. So the publication equation is that publication plus imputation plus identification equals defamation. With a defence, it's very safe publication. Without a defence, it is a high-risk publication. So remember that equation. If I've published a defamatory statement, but I have a defence, it's a safe publication. Without it, of course, it is not. So the key questions you need to ask yourself in this area of the law are these. Is what I am about to say defamatory? In that, does it cause others to think less of them? Am I publishing something about someone which, when others read it, will cause them to think less of them? Or does it damage and injure their reputation? If so, do I have a good defence? If I don't have a good defence, it's a dangerous publication. If I do have a good defence, then it's a safe publication. And that is the essence of what we're talking about when we say the defamation equation is something that you need to keep in mind. As I say, reputation's a movable thing, and you may think in some circumstances you can say more robust things about, for example, a convicted drug trafficker, than you may be able to say something about the Anglican Archbishop of Sydney, for example. Because both enjoy reputations. However, one may have an enhanced reputation and more easily defamed than the other. What can be defamatory? Anything published or written or broadcast in the media, it can be defamatory. It could be a letter, it could be an image, it could be an internet post, it could be anything that is said or even a gesture, and anything else which may be communicated to another person. So it must be published, it must be communicated to someone else other than the person to whom you intend it. You can't be guilty of defamation for saying something to a person if no one else heard it, or no one else could read it, or no one else saw it. So anything published or written, there used to be in the law an ancient definition between libel and slander. Libel were things that were written or broadcast, and slander were things that were said, spoken. Those distinctions have been abolished by reforms to the law of defamation and now no longer apply. Who can sue for defamation? Any living person can sue for defamation. Dead people can't sue. Small companies that is less than 10 employees can sue. Not-for-profit organisations can also sue. Importantly, who can and who can not sue? Large companies can't sue. Neither can governments, local authorities, or unincorporated organisations. So you're entirely able to say, for example, that Coca-Cola are a bunch of criminals who cause childhood obesity and their behaviour is despicable. that doesn't mean that the chief executive of Coca-Cola can sue you. Although, just be careful about this, though, when you make accusations against companies. Corporates can't sue if you can make sure that the accusation is general against the company. But if I said, for example, Coca-Cola is a corrupt organisation that is causing health problems around the world, that's a defamatory statement. But however, Coke can't sue because they're a company. However, if I said this, the management of Coca-Cola are engaged in a worldwide program to cause obesity amongst young people. Well, I'm now talking about the management. That may be a smaller group of people, and it may be held that identifies, for example, a managing director. So just be careful about how you describe a corporate. Corporates themselves can't sue, but the management certainly can if they're identified. Same, any living person can sue, but dead people can't. So you're quite free to defame the dead. So if I said, for example, writing a story about a war veteran who was killed in action, I could say, look, contrary to what is widely written and read about this person, he wasn't a war hero at all. He was, in fact, a coward. And I write an article about what I believe actually happened in his so-called war exploits. Now, his relatives may be very, very distressed at this publication and may feel that it's appalling and defamatory, but sadly, they cannot sue because the person I have defamed is dead. Just make sure in the piece that I don't, by extrapolation, include his family in any character assessments that I make. The plaintiff must essentially prove three elements to make out their case. They must prove, one, that the matter was published. There must be publication. They must also prove that the matter was, that the person was identified in the publication. And thirdly, they must prove that there was a defamatory meaning attached to the words used. So three elements. It must be A, published. So unless the thing is published, you can't proceed, and you must make sure that the person is identified. There must be a clear identification of somebody, and thirdly, there must be a defamatory meaning. So let's look at some of those elements in turn to establish just what you need to make out these particular elements: publication, identification, and defamatory meaning. There's a two-stage process in a defamation trial. Firstly, there is a hearing on questions of law, and at this point the jury is not involved. But the questions are these: is the material capable of conveying the alleged defamatory imputations? And are those imputations capable of bearing a defamatory meaning? So these are questions of law, and these are argued by lawyers in front of a judge and decided by the judge. It's called the first stage of a defamation trial in New South Wales. Is the material capable of conveying the alleged imputations? And in fact, are those imputations capable of bearing a defamatory meaning? Now, if those two questions are made out, we then move to the second part of the defamation hearing, which is whether an ordinary reasonable person would in fact have taken the material as conveying the alleged imputations. Now, whether that person would in fact have understood such imputations as being such as to cause ordinary reasonable members of the community to think less of the plaintiff. So in other words, first of all, it has to be established legally whether or not the material is capable of being defamatory. Now, if the court has decided that, and if the court has decided that, yes, there are defamatory imputations present, the jury then decides, in the second stage of the hearing, the jury decides whether or not, in fact, the ordinary reasonable person would have felt that their reputation was damaged in those circumstances. So, first, questions of law, and secondly, questions of fact. The jury hears the questions of fact. The judges decide the questions of law. In many instances, defamation trials pretty much end after the first stage because a defendant may feel that having lost the legal part of the proceeding, that is, whether or not there were defamatory imputations present at all, that once they've lost that part of the proceeding, they may feel that it's better to settle because they'll be in very uncertain waters in front of a jury. So let's look at some of these, the three main elements. Remember, publication, identification, and defamatory imputation. Element number one, publication. Publication occurs in each place where the defamatory material is seen or heard. So in other words, everywhere somebody reads it, that's where it's published. In Australia, the law applies in the jurisdiction where the harm is caused by the publication as a whole has its closest connection. What about websites? Well, there's the law is in an interesting stage of development here. There's a famous case involving Melbourne mining magnate called Joe Gutnick, and he took a defamation against an international publisher, Dow Jones. They operate out of New York. They published a mining newsletter. Mr. Gutnick was a miner. He's quite well known in mining circles here in Australia. Now, the newsletter that he subscribed to, as I say, was published out of New York. It was a subscriber-only newsletter. Mr. Gutnick read a copy of the newsletter and concluded that he had been defamed in the newsletter and wanted to take action. Now, Mr. Gutnick lived in Melbourne. The newsletter was published in New York. Dow Jones, who were the defendant, publishers of the newsletter, said, well, if you want to sue, you'll have to come to New York and sue us here. However, in an important case, the court decided that no, publication occurs where Mr. Gutnick downloaded the material. This was an online publication. And the court held that Mr. Gutnick was able to sue in Melbourne because he had downloaded the publication there. And what's more, of course, that's where his reputation had the greatest amount to suffer. So in essence, publication occurs where the material is downloaded, given that that's where the plaintiff has the greatest association with and the greatest reputational loss that's likely to flow if the material was published. So it's not just where so the fact that you publish it in one jurisdiction doesn't mean you can't be sued in another jurisdiction, in other words. Element number two, we're just back on publication. Publication is a very important point, though, because remember, you can't defame somebody unless you do publish it. So if I, for example, ring someone up and abuse them and accuse them of being a crook, etc., provided no one else hears the conversation, then it's not defamatory. So if I write a letter to somebody, for example, or send them an email, provided I can prove that no one else saw it, then I'm probably safe from a defamation action because I can conclude that no one else saw it, therefore it was not published. You can't be guilty of defamation for saying abusive and defamatory things to someone who can then sue you. Someone has to hear it. There must be some loss of reputation. Otherwise, there is no defamation. Now, just back. This has a practical sense, I suppose. If you wanted to avoid defamation and you wanted to say something to somebody, make sure you say it in private. Just be careful of emails, by the way, because these days, of course, emails are held on servers, and emails are frequently seen by many other people other than the recipient, or are capable of being seen by people other than the recipient, so therefore they will be deemed to be published. Element number two, identification. Now, the material must be reasonably referable to or of and concerning the plaintiff. In the clearest case, of course, the plaintiff will be identified by name. The person will be named, and therefore there's no question about identification. But what about if a person wasn't named but it was implied? You don't need to expressly identify someone. You could say, for example, members of the cabinet. Now, that's a pretty small group. Members of the Bondi police station, for example. Now, there may not be that many members of the Bondi police station. So if a person reading a publication about which refers to nefarious practices at the Bondi police station, if there's only 5 constables there, they might think, well, hang on, there's only 5 of us. I think that publication reasonably refers to me as an individual, and I can prove that somebody reading it thought, well, hang on, I know somebody works at the Bondi police station, it must be about them. So it must be capable of identifying the plaintiff at the time of the publication. You can't rely on subsequent information. So in other words, unless the person was readily identifiable at the time of the publication, you can't rely on subsequent information that leads you to identify them. Just giving a person a fictional name doesn't help you. If someone can give evidence in court that they read the name of the fictional person and thought, oh, well, hang on, that's really so-and-so. So those disclaimers in front of books which say all characters in this work are fictional, works of fiction and no reference to any person living or dead is intended, really don't mean much legally, because as a matter of law, if a person can be identified, even if though they've been given a fictional name, then they have been identified. So just be careful that just changing a person's name doesn't prevent you from a defamation action on the basis that the person wasn't identified if evidence is given that somebody who knew the person read the publication and thought, well, hang on, even though you called him Joe Bloggs, I really know that you're referring to Adam Smith. And there you go. The identification test is, would the plaintiff be identified by the ordinary reasonable person with knowledge of the plaintiff? That's the test. In other words, the ordinary reasonable person test, commonly used in the law, is applied here. Groups as a whole can't sue, but individual members can if the statement can be reasonably read as referring to each member. Much depends on the size of the group. The smaller the group, the bigger the risk. The degree of individual identification, the generality of the charge, and the strength of the accusation. Fictitious works, as I say, fictitious work may be defamatory if the name or attributes of a fictional character are understood by ordinary reasonable people as referring to the plaintiff. There's a famous case of Artemis Jones in England, which set this principle out, that there was a satirical work about a gallivanting libidinous lawyer called Artemis Jones. The only trouble is there turned out to be a real Artemis Jones, and he was a lawyer, and he took great exception to being characterised in this way. The defence that it was just a fictional character was not upheld. Remember, the ordinary or reasonable person has to make this judgment. This is an important test in the important concept in the law. The ordinary or reasonable person is a person of fair average intelligence. They're not perverse or morbid or suspicious of mind. They're not avid for scandal. They don't live in an ivory tower. They do read between the lines in the light of general knowledge and worldly experience, but they're lay people. They are not lawyers. Now, we come to a very important area of discussion, and this is the area of imputations. So we've discussed publication, we've discussed identification. Now let's talk about defamatory imputations, which is the third leg. Remember, there are three elements present for defamation. It must be published, person must be identified, and there must be a defamatory imputation. Imputations are a tricky area, and for non-lawyers, of course, it can be a revelation as to what you sometimes might have to defend. In defamation, you see, you are held liable not only for what was said on the surface, but also for what was the secondary or reasonable meaning arising from what was said. Now, these are called imputations. In other words, what was imputed by the piece is just as defamatory as what was explicitly said by the piece. Now, this is, as I say, a very, very important area of the law. It's important that you understand it as well. We'll discuss this in part 2 of this lecture.